This is Bloomberg Law with June Grasso from Bloomberg Radio.
Sam Bankman-Fried is appealing his conviction and asking for a new trial. The FTX founder argues that everyone rushed to judgment after the company's collapse and that fair trial principles were swept away in a, quote, sentence first, verdict afterwards tsunami. Bankman-Fried was convicted in November of orchestrating a years-long multi-billion-dollar fraud at FTX, the crypto empire that imploded in late 2022. He's serving a 25-year prison sentence imposed by federal judge Lewis Kaplan, and in the brief, blame is placed on the judge. Bankman-Fried's attorneys claim that many of the judge's rulings were not just erroneous, but unbalanced, repeatedly putting a thumb on the scale to help the government and thwart the defense. His lawyers asked the Second Circuit to reverse his conviction and assign the case to a new judge for a retrial. Joining me is Bloomberg legal reporter Chris Domesh, who covered the trial and has read the legal brief. A lot of it is a direct attack on the trial judge, Lewis Kaplan, and not just incorrect rulings, but that he had a bias against Sam Bankman-Fried and his trial team.
Yeah, it's a very interesting appeal. You know, most criminal defendants who are convicted almost always launch an appeal, especially white-collar defendants. And they often attack legal rulings that are made during the trial, whether it be during jury selection or, you know, what witnesses were allowed to testify about and various things like that. But this appeal seems to just kind of go beyond the normal challenges to legal procedure and, like you said, directly attacks the trial judge for a wide variety of what Sam Bankman-Fried's lawyers say are reversible errors, that he was biased against them from the beginning. The one thing they really attack is his decision to, you know, not allow Bankman-Fried to use the defense that he was, you know, relying on good faith on lawyers' advice. And that attacks what was widely seen as kind of an unusual move to question Sam Bankman-Fried outside of the presence of the jury about his interactions with lawyers. It was very unusual move and don't see that a lot in trials, so it's very reasonable to see his lawyers go after that. But they've also kind of just talked about the fact that the judge routinely had issues with his lawyers during the case, you know, often interrupted cross-examinations and frequently interrupted Sam's own testimony to interject and often just didn't think he was telling the truth. So whether or not that is a successful defense is yet to be seen. Trial judges are generally given a big leash when it comes to their decisions in trials. But this is a pretty significant argument on appeal, and it's going to force the government to respond in length, and I anticipate that we're going to hear a lot of questions from the appeals court judges once this gets to an oral argument.
Well, as I recall, the judge was sarcastic at times with the defense counsel and the defense.
For sure. I mean, more than I've seen in many criminal trials where judges are generally deferential and more serious and more just kind of wedded to procedure. And Judge Kaplan clearly was, I don't want to say annoyed because, you know, a judge's temperament on the bench is not necessarily a reflection of their personal animosity and more just, you know, an annoyance with failure to adhere to procedure and things like that. But it was an unusual amount of in-trial commentary before the jury that I haven't really seen in a lot of criminal trials.
Also, you mentioned this, but they argued that, so before he allowed Sam Bankman-Fried to testify, he had a little sort of voir dire of Sam Bankman-Fried. He put him on the stand and he asked him questions, which was really unusual for a defendant who's going to testify. And Bankman-Fried's attorneys say that was an unprecedented proceeding that permitted a prosecutor to conduct cross-examination going way beyond the supposed purpose of this preview hearing. I mean, it was a strange hearing.
There's no doubt about that. Basically, his lawyers say that he was essentially deposed by the judge, especially when a defendant testifies. As we all know, that is a rarity in United States criminal trials just because of the potential issues it raises in terms of what you can be questioned about on cross-examination. And it opens the door to a whole lot of other acts that may not have come into the case had you not got on the stand. But the judge basically, he questioned Bankman-Fried directly without the jury in there. And it was just a very unusual proceeding. It was kind of hard to believe it was happening at the time, but, the judge wanted to hear from him, and he was clearly skeptical of his testimony before he questioned him. He was skeptical of his testimony when he questioned him, and then he was skeptical of his testimony when he got on the stand. So that does seem to be the heart of their attack on this procedure, and if there is anything that might give the appeals court judges pause, it might be that. But like I said, trial judges are often given a lot of deference in terms of their decisions. Any appeal is a long shot from a jury conviction.
They do have a lot of latitude, but there is a point where it stops. They also said that the jury only saw half the picture because the judge didn't allow some critical evidence in to back up. Sam Bankman-Fried contended that FTX had enough funds to cover customer withdrawals, so the government's narrative that the money was lost permanently was incorrect. And in fact, FTX's customers are going to receive 100% of their money back, right?
Right. That is another key part of their appeal. And in fact, there's an interesting parallel to that in the case of Martin Shkreli, who was, convicted at trial, but also argued that his hedge fund investors hadn't lost any money. There was plenty of testimony during his trial that, that they had actually made money rather than lost money from the alleged conduct. But in the end, that didn't succeed for Martin, and it might be hard to say that would succeed here.
Something that I thought was unusual when it was happening, I don't know that it's reversible error, but they say that the judge, quote, improperly prodded jurors to reach a quick verdict because he invited them on the first day to stay late, and he offered rides home and meals. I thought that was unusual. I mean, the trial had been so long. What was the rush?
Yeah, that took a lot of people by surprise in the press room and among the observers that day when that happened. And a lot of us wondered if that wouldn't prod the jury to come to a verdict that day. And in the end, they did. I think it was about 20 or 30 minutes before 8 o'clock. So that is something they definitely probably should have raised in the appeal brief and did. And it will be questioned. Judges often have a lot of latitude in terms of how they instruct the jury. It's not unusual to see a judge ask the jury if they want to stay later in a case, what time they want to go to. They're often very hesitant to kind of give them any kind of formal parameters for time. Jury generally, work on a regular schedule, 9 to 5, whenever the court is open. They go home on a regular time during the day during the trial. But when it comes to deliberations, things are a lot looser, and the judge is usually pretty hesitant to kind of restrain them in any way from their deliberations. If they want to stay late and continue talking, if they think they're making headway, he will allow them to. But hearing him directly say, you can stay late tonight, as late as you need, and promising them meals and rides was definitely unusual. Whether or not it's reversible error, like you said, who knows?
We've said unusual quite a few times in this short conversation.
There's a lot of different things about this case.
We should mention that Judge Kaplan has been on the bench for a long time and is a very highly respected judge.
There's no question about that. And he's had a lot of experience with cases. I think he thinks he knows the law very well. And as I've said numerous times during this interview, judges have especially trial judges have a lot of leeway. Now, it's not inconceivable that some part of the pretrial procedure could be called into question by the appeals court that maybe results in a new trial or something, but it's hard to say at this point.
And when the judge sentenced Bankman-Fried to 25 years, did he say anything during the sentencing that hinted at bias?
I don't know about bias. He didn't believe them. He didn't believe Bankman-Fried. He essentially said he's at risk to commit more crimes. He called him out for his lies, and whether or not he was biased or not, he just thought that he was clear that he thought that he was not telling the truth.
The state's star witness, Caroline Ellison, the former girlfriend of Sam Bankman-Fried, is going to be sentenced next week by Judge Kaplan. Her lawyers filed papers asking that she be given no jail time at all, citing her cooperation. Do you know what the range is that she's facing?
Well, the guidelines range is life in prison, which is not going to happen, and is driven by the loss in the case, or the alleged losses in the case, and the size of the fraud.
Her attorneys asked for no time, and the probation department said no time, which I thought was unusual.
That's not really that unusual for cooperating witnesses. Yes, they're asking for time served with 3 years of supervised release, and they're citing her extraordinary cooperation with that. I don't know what the government will ask. We'll see when they file their sentencing memo sometime this week.
The sentence will be solely up to Judge Kaplan. We'll see how much he credits her cooperation. Thanks so much, Chris. That's Bloomberg legal reporter Chris Dolmesh. Will be sentenced in November and October, respectively. Coming up next on the Bloomberg Law Show, since the reversal of Roe v. Wade in 2022, every ballot measure on abortion rights has been approved by voters. This November, an unprecedented number of abortion initiatives are on state ballots, but some may face uphill battles after rulings by state courts. You're listening to Bloomberg. Since the overturning of Roe v. Wade in 2022, legal battles over abortion laws have been fought across the country in the more than 20 Republican-led states that have banned or restricted abortions. This November, the battle will be decided by voters, as a record number of abortion initiatives are on the ballots in at least 9 states. In the last 2 years, every ballot measure preserving abortion rights has been approved by voters. But can that record be preserved after legal challenges by abortion opponents have led to ballot measures with language describing a fetus as an unborn human being, others with financial statements about the negative fiscal impact of abortions, and even opposing abortion measures on the same ballot in one state? Joining me is Mary Ziegler, a professor at UC Davis Law School. How would you characterize the challenges to abortion initiatives in general? Are they technical or substantive?
Most of them are technical. There are a lot of them that involve whether a ballot measure satisfies what's called the single subject requirement. There are challenges about the procedures by which signatures were gathered or submitted. So most of them either involve election law or the requirements for a ballot to be put before voters. They don't actually deal with substance.
Let's look at some of the states where they have ballot measures. So in Arkansas, the Secretary of State rejected it because they said they hadn't followed the rules to paid canvassers.
Mm-hmm. Yeah, so essentially the people who were submitting the ballot measure in Arkansas had been submitting required paperwork for paid canvassers on a rolling basis, and then when they reached the requisite number of signatures had finalized the paperwork. The state complained that they hadn't essentially filed everything at once, and as a result that it was hard for the secretary to evaluate, especially paperwork about whether paid canvassers had received training about signature gathering. So it was about that paperwork and the timing of its submission.
Is it going to be on the ballot or?
No. So the Arkansas Supreme Court affirmed that decision, and that will not be going before Arkansas voters in November.
So it was just because the Secretary of State was finding it hard to count the signatures?
Yeah, I mean, it's pretty technical, right? So, I mean, the dissenting judge in the Supreme Court's opinion said essentially, all of the requisite paperwork was there, and the complaint was about when and how it arrived, but substantively there were all the tools needed for the secretary to evaluate the signatures, and the majority essentially said, we're going to enforce the letter of the law, a kind of formalism, regardless of whether there would have been a way to evaluate the signatures and the training either way.
So still with the A's, Arizona. So first, on the proposed constitutional amendment, there's a description of a fetus as an unborn human being. That was approved by the state Supreme Court.
Correct, yeah. So the state Supreme Court approved that as a description that could go before voters. Again, it's a slightly different question because the Supreme Court didn't actually prevent the measure from going before voters, but suggested that language wasn't misleading and that voters could, essentially wouldn't be adversely affected by it.
So I take it a lot of these challenges are to the wording of the ballot measure, which can confuse voters.
Right. I mean, I think that the objection to that language was that it was very partisan, that it would essentially convince voters that the ballot measure should be rejected, and that it took a position that was more aligned with the pro-life or anti-abortion movement than a neutral position. And so that was the objection that the state Supreme Court rejected.
One of the proponents of abortion rights said that it's going to be the longest ballot in state history. It's going to have 2 pages and 13 ballot measures taking up the back of the second page. Was that inadvertent, or was that done to, make it harder to find the abortion measure?
Yeah, I think that it was done to potentially diffuse these kinds of legal challenges. I think supporters of abortion rights in Arizona are aware of the fact that the Arizona Supreme Court had allowed, a pre-Civil War abortion ban to go into effect. There's an assumption that the court was and is quite conservative on questions of abortion. So I think this was an effort to be thorough and kind of block those kinds of challenges at the pass.
So in Florida, which it's gotten a lot of news because the governor seems to have pulled out all the stops, there's a Florida Cares website, and it has the state seal on it. I mean, has anyone challenged that using the state seal? And apparently there's misinformation on there.
I don't know if anyone has challenged it yet, but I think this is sort of part of a broader use of state power in Florida to try to block the ballot, or at least defeat the ballot initiative after the state's effort to keep the ballot initiative from going before voters failed. We've seen some analogical things happen in Ohio before that state voted on its ultimately successful ballot measure. We may see legal challenges to it, but I think the Florida Supreme Court, like the Arizona Supreme Court, is quite conservative, so those challenges may not work.
Governor Ron DeSantis had a squad of election police going to the homes of those whose signatures are on the petition for the abortion measure, questioning them. That has to be, at the very least, a stressful experience. Has that been done before in other states?
I mean, it's certainly unusual. We haven't seen this kind of level of, I guess you could say, intimidation before. Governor DeSantis' office argues that there are valid concerns about, essentially about fraud in the gathering of ballot signatures that they're investigating, but of course sending law enforcement of any kind to somebody's door as part of a fraud investigation before voting has even begun is going to have obviously intimidating effects that I don't think are accidental. So I think this is yet another thing that we're seeing in this election with ballot initiatives that we haven't seen much before.
Also, the Florida Supreme Court is allowing a financial impact statement to be included alongside the measure on the ballot. That statement says an increase in abortions may negatively affect the growth of state and local revenues over time. Is that the first time that's happened, a financial statement like that?
To my knowledge, it's the first time that it's appeared on the ballot. Again, in Ohio, we've seen state lawmakers and state resources used to make arguments against a ballot initiative before, so that's not new. But I think the focus on cost is new. I don't think that's surprising, again, because abortion opponents have lost a lot of past ballot initiative campaigns, and so they're trying new strategies to see if they can change their luck.
In Florida, 60% of voters are needed to pass the abortion ballot measure. With these measures, is it usually just a majority or sometimes a supermajority required?
All of the ballot measures we've seen so far, again, not all of which were designed to codify reproductive rights. Some of them were narrower, like rejecting an anti-abortion proposal. All of them just had majority requirements to pass. So this is the first time we've seen a supermajority requirement. So it'll be interesting to see if that makes a difference for abortion opponents. Clearly in Ohio, there was some belief that it would. There was an effort to get Ohioans to raise the threshold for successful ballot measures in a separate ballot measure. It failed, but Florida already has the 60% threshold, so it'll be interesting to see if that's enough to help abortion opponents or if the momentum for abortion rights is just too significant.
In Nebraska, for the first time in state history, there are going to be conflicting petitions on the same ballot. On Friday, the state's top court ruled unanimously against the argument that the Abortion Rights Amendment violated the state's single-subject rule. I think you referred to this before.
Single-subject rules have been the subject of a whole bunch of litigation in a lot of states. They're applicable in a lot of state constitutional contexts, and essentially they apply to say that a ballot measure can only discuss a single subject. And the rationale for them is that voters would get confused if you cram too much into a single ballot measure, or particularly if you kind of interpolate a really unpopular proposal into an otherwise popular ballot measure. So the idea behind the suit in Nebraska was that there was more than one subject being covered because the ballot measure addressed abortion, abortion restrictions, and viability, which opponents said were discrete topics. And the Nebraska Supreme Court rejected that idea and said, of course, if there's a right to abortion, that's going to have obvious impact on whether restrictions can be imposed on that right. That's one and the same subjects. And that since the decision of Roe, viability as a concept has been entangled with whether there are abortion rights. But this kind of single subject rule argument had been raised not just in Nebraska, but in a variety of other states as well. So we're likely to see more of it.
So how will it work with two competing ballot measures? I assume the language in each is going to be different. It sounds so confusing.
Exactly. So the two Nebraska ballot measures, the one that we were just discussing, the kind of pro-abortion rights ballot measure, looks a lot like a lot of other ballot measures in the sense that it's trying to establish some kind of reproductive right. The anti-abortion ballot measure kind of plays around with what is currently the status quo in Nebraska, which is that abortion is more or less legal until 12 weeks. But the ballot measure, instead of saying, okay, let's stick with the status quo, constitutionalizes it, meaning there would be no constitutional possibility of allowing abortion after the first trimester. So it's confusing both in the sense that voters have two ballot measures and also because the second ballot measure may feel to voters just like the status quo, but in effect would be putting kind of a constitutional limit on when abortion would be permitted.
So whichever measure gets more votes wins, or is there a 35% threshold?
Yeah, it's kind of confusing.
So
my best understanding from talking to people in Nebraska is that if both of them have, obviously the easiest scenario is neither of them have the votes to pass or only one of them has the vote to pass, in which case if neither of them have the votes to pass, then it's just going to be whatever the status quo is in Nebraska. If both of them have the votes to pass, then that's when it gets complicated. My best understanding is that the one with the more votes would be the one that would be enacted into law. But you can bet that if both of them have the votes to pass, that would get litigated. I don't think that we would just see that settled straightforwardly. I'd be a little surprised if both of them did have the votes to pass, of course, because voters are seeing lots of ads that juxtapose them and say that they're diametrically opposed.
It seems like with all this, the confusion, intimidation, et cetera, that it becomes even more important that voters be educated about the ballot measures before going to vote.
I think that's right. There's also a question of just how much misinformation is really penetrating or not penetrating. So in another example, another single subject challenge and other challenge that failed recently was in Missouri, where a ballot measure will go before voters. And there the strategy has been for conservatives to argue that the ballot measure, which would create a right to reproductive health care, will actually force Missouri to legalize cloning and gender-affirming care, which they're arguing would fall under the umbrella of reproductive health care. The goal there, obviously, is to convince Missouri voters who don't support gender-affirming care or cloning that this is like a Trojan horse that will cover those things when ultimately the interpretation of the ballot initiative's language will be done by the Missouri Supreme Court, which is generally quite conservative. So I think there's also been an effort to confuse voters about exactly what they're voting for. I don't know to what extent that's working and to what extent voters understand these ballot measures based on what's going on more broadly in their state when it comes to struggles over abortion. But I think that'll be another big question going into the election.
Yeah, so far, with all these legal challenges having led to language that's unfavorable in some states, confusion in others, even opposing abortion measures on the same ballot in Nebraska, could we see some of these initiatives defeated in November for the first time since Roe was overturned?
Yeah, it's definitely possible. It's worth emphasizing, right, that what the abortion rights movement is trying to do in this election is objectively harder in a variety of ways, right? So there are several states in which ballot measures are going forward that are just much more conservative than any we've seen ballot initiatives in to date. So as much as Ohio is a red state, Ohio is not as conservative as South Dakota or Missouri, right? I mean, we're seeing, for example, a competitive Senate election in Ohio. We're not seeing anything like that in South Dakota, right? So, one, you're just going to much more conservative states with actual measures backing reproductive rights. In other words, not just saying something more incremental like we saw in Kentucky or Montana in 2022. It's harder because in some instances, like in Florida, there's supermajority requirements. It's harder in some instances because the state, as in Florida, is using resources to try to defeat the ballot measures. It's also harder, I think, because you're seeing, something in a presidential election year where people who are conservative may change the way they're thinking of this issue in part because they vote the same up and down the ballot. And there's confusion, as we see in Nebraska, when you have more than one ballot measure that voters can choose between without necessarily understanding the stakes. So I think that it's definitely possible. It's one of the toughest tests for sure that we've seen with ballot initiatives since Dobbs.
We'll be following all these ballot measures come November. Thanks so much, Mary. That's Professor Mary Ziegler of UC Davis Law School. Coming up next, TikTok does not fare well in the D.C. Appellate Court. I'm June Grasso, and you're listening to Bloomberg. Time may be ticking away for TikTok and its more than 170 million U.S. users. The Chinese owner of the wildly popular social media app has until January 19th to sell the app or face a ban in the U.S. And it appears the D.C. Appellate Court is not going to be much help, judging by the grilling TikTok got from a 3-judge panel, which was skeptical that the law banning the video sharing app would violate the company's free speech rights. Joining me is Matthew Schettenhelm, Bloomberg Intelligence litigation and government analyst. Matt, explain the issue here, why TikTok has been under scrutiny for so long.
So TikTok fell under scrutiny for two main reasons. One, a concern about potential propaganda that with TikTok's parent being located in China, that there was the potential for China to influence the content that 170 million Americans are seeing. And a second concern is with data privacy, that all this information about what 170 million Americans are clicking on or even where they're located is potentially, again, running back to a company that's located in China. And that potentially raises concerns with China's access to potentially very sensitive data. And so those two things really drove legislators into passing what became law in April.
And tell me about that law.
Basically, this law says, it passed in late April, as I said, and it says it from 270 days after that passage, which takes us to January 19th of 2025. On that date, no company can carry TikTok in an app store or carry it on a server in a way that allows the app to be distributed or updated or maintained in the United States. And if companies continue to carry it in their app stores or to carry it on servers, they would face severe potential liability and penalties and enforcement. And the only path around that Congress allowed is for TikTok to divest the company, for the company to be sold to a company that doesn't have a parent located in China. But TikTok has said, look, that is not feasible. We are not able to do a divestiture in 270 days, technically, legally, for a number of reasons. So they've effectively told the court, look, that's not happening. And instead of doing that, they've brought a First Amendment challenge to try to challenge the court. And that was what we heard at the D.C. Circuit on Monday morning was the argument in that case.
So the hearing was scheduled for 50 minutes and it ran for about 2 hours. And what was the main issue?
Certainly the First Amendment. So TikTok threw a number of arguments against this law. Its lead argument was the First Amendment, and that's all the court reached. That's all the court talked about. We never reached the takings clause claims or the bill of attainder issues. this is going to be won or lost for TikTok on the First Amendment. And TikTok really made the argument that this is an unprecedented speech restriction in the United States, that this is one of the leading social media apps. 170 million Americans use this for communicating, for speech every day. And you're forcing the sale of it. And it's as if you would force the sale of Politico or Twitter X because you don't like the owner, because the government doesn't like who's controlling it, and you're going to force a sale of it. They say that's unprecedented for the government to use that level of control and to do it for secret reasons. A lot of the evidence was secret. And so the briefing focused on that issue. The argument focused on the First Amendment issue, but probably not in the ways that TikTok would have liked.
Tell us why TikTok didn't fare well.
Yeah, I thought it was a very tough day for TikTok. Even though the court explored the First Amendment issue, it didn't do it in the ways that I think TikTok would most like. TikTok really pushed the argument that this should be subject to strict scrutiny, which is the highest level of First Amendment scrutiny. And it's very tough for the government to win a case that is governed by that standard. I saw little appetite from the three judges on the panel to go to strict scrutiny. They didn't want to go there. Where they wanted to go was intermediate scrutiny, which is an easier test for the government to pass. And so I think that was a concern. One of the judges on the panel, Naomi Rao, Trump appointee, brought up a 1988 case that the government hadn't even cited about the government's ability to shut down an office with ties to a foreign country of concern, and said, look, we rejected a First Amendment case in that. And similarly, another judge, Douglas Ginsburg, a Reagan appointee on the panel, really expressed sympathy for the government's interest in managing national security threats and foreign affairs. You know, TikTok pushed the point that, look, Congress never made findings about what is wrong with TikTok. They passed this very quickly. And if you look at the law, there are no reports tied to this legislation saying why you needed to take this extreme measure. I thought that might get more traction with these judges, but instead they were much more deferential to Congress, much more concerned about stepping on Congress on a national security matter, something these judges aren't expert on. Naomi Rao at one point said, look, you're asking us to treat Congress like an agency, the way we would review a federal agency, and we don't do that in the same way. And basically there was a sense that they were going to be much more deferential to Congress's judgments on these national security threats. And so if I was TikTok walking out of that argument, I would be concerned.
The government's lawyer said there are just reams of information that are going back to China. Is the information secret and we haven't seen it, or is there no information that they keep claiming that TikTok is a threat?
I think the government is willing to concede that so far they haven't seen direct evidence of China doing what they're most concerned about. So China influencing the propaganda, or China diving into this personal data. What the government has said, though, is that there is an extreme risk with this setup, with allowing a parent of TikTok to be in China. And that in itself is so inherently risky that it's reasonable for the government to proactively address it, and not to shut down TikTok necessarily, but to say that you will be shut down unless you sell the company to someone that doesn't have a parent in China. And we're kind of reading through the lines a little bit, because a lot of the briefing material was redacted and confidential. You know, I think dozens of pages in the government's brief. But I do think in other parts that weren't redacted, they did concede that we don't have hard evidence of this happening yet. And so I thought TikTok might get a little more traction on the fact that the government's doing a lot of this for secret reasons. And what's really remarkable, sometimes you'll see cases with redacted information that the public can't see, but at least both sides of the case can see it. Here, even TikTok can't see the evidence against it. The government was only sharing this information with the courts on an ex parte basis. And so that's sort of remarkable in a First Amendment case. But if you look through the transcript of yesterday's 2-hour hearing, that got mentioned hardly at all. And so TikTok made very little traction about raising concerns about the government using secret evidence for this. And instead, You heard a lot about sympathy to the government in addressing a national security threat. So concerning if you're TikTok, I think.
You give TikTok just a 20% chance of success at the D.C. Circuit?
Yeah. So, going into this argument, I viewed this as a very close case. And on the briefing, I thought TikTok did a pretty good job of raising concerns that might give these judges pause about allowing such a drastic measure. But TikTok got so little traction with those three judges yesterday. Two of the three, the two Republican-appointed judges on the panel, I find it very difficult to see them ruling for TikTok. The Obama appointee, maybe he was a little more neutral on the panel, but still, most likely this is going to lead to a decision at the D.C. Circuit that upholds Congress's law and most likely leaves that January 19th deadline for an effective ban in place. And so I think we're likely to see that decision by early December.
TikTok, if it loses, could appeal to the full D.C. Circuit, which would have more Democratic appointees on it, or could try to go to the Supreme Court. What do you think it's likely to do?
That's exactly right. So the problem here is that time is extremely tight. Normally, you'd pursue every option you can. And so, okay, let's try asking the full D.C. Circuit first. And if that fails, then we'll go to the Supreme Court. But when TikTok has to do all of this by January 19th, then it might not see a decision until maybe December. So time could be really short here. And if this decision goes the way I think is most likely at the D.C. Circuit, with Srinivasan, he's the chief judge, was the Obama appointee on this panel. If he rules against TikTok and two Republican-appointed judges rule against TikTok, I don't think there's going to be much chance that en banc, the D.C. Circuit, is going to second-guess those three judges. And given the shortness of time, I think TikTok says, look, we're not going to win at the D.C. Circuit. Let's try at the Supreme Court. That's our best bet. And asking the Supreme Court justices, this is such an unprecedented First Amendment issue for the government to do this. We should at least ask the Supreme Court to freeze this January 19th deadline and take up this case to consider the important First Amendment issues. And so I think that's what you'll see if TikTok loses in December, is an emergency request to the Supreme Court to hit pause on this. Slow this down, and let's think about whether the government really satisfied the First Amendment or not.
Because it doesn't seem like this Supreme Court would be any more sympathetic than the judges at the D.C. Circuit were.
I agree with you. And especially one thing that came up at the D.C. Circuit yesterday was when the Supreme Court on July 1st decided the net choice case, the First Amendment case there, Justice Barrett put in a sentence in her opinion that said, even though this opinion gives First Amendment rights to these social media companies, maybe the analysis is different when there are ties to a foreign company. And the judges at the D.C. Circuit yesterday kind of latched on to that and said, yes, it's different in matters of foreign control. And with the Supreme Court makeup of 6 Republican appointed judges, 3 Democratic appointed judges, I think it's very likely that a majority of that court is going to agree with this panel at the D.C. Circuit, which also is 2 Republican-appointed judges, 1 Democrat-appointed judge. It's going to be a really tough decision to reverse at the Supreme Court. I think TikTok is really up against it in trying to do that. It is possible, I guess, that the Supreme Court would say, look, it's at least important. And so this is important enough, we should hear it and slow it down. But TikTok ultimately winning is going to be a really tough sell with the Supreme Court.
Great analysis, Matt. Not for TikTok, though. Thanks so much. That's Matthew Schettenhelm, Bloomberg Intelligence litigation and government analyst. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news by subscribing to the Bloomberg Law Podcast or downloading the show at bloomberg.com/podcast/law. I'm June Grasso, and you're listening to Bloomberg.